Good morning or good afternoon, everybody. This is Chris O'Brien from the Venable Law Firm, and welcome to our presentation today, Nuts and Bolts of an NFT Deal, your guide to NFTs, the metaverse, and Web3. With me today are two of my partners and associate, Josh Kaufman from our DC office, who's one of the premier experts in the country on art law, Jim Nelson, who I work very closely with, who's one of our IP transactional partners in San Francisco, and Chris Boone, one of our regulatory partners in Washington, D.C., who's very deep into the crypto space. I am a transactional lawyer in Los Angeles and also the co-chair and co-founder of our crypto practice, which I've been doing for about 6 years. This is part of a series of presentations that we're doing this week on NFTs and crypto. There's a module on tax, which you may find very interesting, and a module on how the advertising and promotion space is being impacted by NFTs and the issues there. This program is for CLE credit, and about halfway through, we will give you the code that you need to insert to get your CLE credit. And with that, I think we'll dive in. In terms of the agenda today, we're going to talk about what are NFTs, IP rights, how to actually do one of these transactions, including the IP issues associated, and also talk about liabilities and regulatory issues. Chris, if you go to the next slide, we wanted to start out by talking about the elephant in the room. When we first conceived of this panel, it was back in, I think, October or November of last year, and both the crypto market and the NFT markets were heading towards peaks at that time. And obviously, we're in the middle of a correction. We're probably at the lip of a recession economy-wide, and we all can see what's going on with the crypto markets. NFT markets have been correcting for months. The cryptocurrency market has also been correcting, but more dramatically lately. We predicted this. This is a long predicted correction in this market. We didn't predict everything that's going on in the economy, but we could see that this was an overheated market. The question is, where do we go from here? Nobody really knows. We don't know if there's more pain in the crypto market and the NFT market. I think we can put one idea to rest, which was that crypto was going to be a hedge against other markets going down or a hedge against inflation. It's not. It looks like a leading indicator and a risky asset class. But I also want to say cryptocurrencies are not the technology. They're an application of the technology. And this correction isn't going to tell us what's going on necessarily in the future. Chris, if you go to the next slide. So if we zoom out a little bit from what's happening today, the total crypto market is much bigger than it was at its last peak. There are more cryptocurrencies, more people are bought in, and cryptocurrencies have become very mainstream with a lot of Wall Street trading. Chris, if you advance to the next slide. And I see parallels here in the dot-com crash. There are plenty of people on this call or Zoom who lived through that in 1999 and 2000, where we saw a lot of blood in the water among internet stocks and companies. That doesn't mean that the internet disappeared. We saw enormous companies, Google, Facebook, Amazon, emerge from that. It didn't speak to the technology. The technology of the internet didn't go away. And some people are predicting that crypto is the future of the internet. We're talking about Web3 a little bit today. Has that been proven out? I don't think it's been proven out yet, but it's a possibility. And the fluctuations of the cryptocurrency pricing today is not going to tell us what's happening in the future. Chris, if you go on to the next slide. This really isn't an NFT basics MCLE. We're going to do a deep dive into the issues here, so I'm not going to spend a tremendous amount of time on this because I think by now most people know what an NFT is. It's a non-fungible token It's a proof of ownership or a certificate of authenticity. It typically either includes or more normally attaches to a digital file that's hosted somewhere and proves that you're the owner of something that's unique or one of 100 or whatever the particular aspect is. They've also moved beyond the original use case, which we'll talk about a little bit, as collectibles. And people are doing a lot of interesting things here, including in-game characters, digital trading cards, ownership interests, a lot of different things. If there's one thing I would ask you to take away from the discussion of NFTs, it's the idea of digital scarcity. I think that's what NFTs have brought into the digital world. I do a lot of my work in the entertainment media space. Frankly, digital has been a mixed bag for entertainment. Digital has very often meant ubiquity. It's meant the ability to copy, and it's impacted rights holders and artists in different ways. Great in some ways, not so great in other ways. NFTs have brought the idea of digital scarcity into the marketplace, meaning you can own and prove you own the original thing, and scarcity creates value. This is one of the reasons we at Venable have been talking about this at least since 2017, 2018, with CryptoKitties, one of, if not the first NFT. I don't even think we were calling them NFTs at the time. But digital scarcity is a big idea. And at the moment, in my view, NFTs are the killer app of blockchain. We may see new applications in the future. This one's here now. People are really making money on this. And I think you'll find this an interesting discussion if you're involved in the space. With that, I want to turn it over to Chris Boone to go a little deeper into the advantages of NFTs.
Right. So the blockchain technology underlying NFTs allows for a number of advantages over traditional media. The biggest one that Chris O'Brien already touched upon is digital scarcity. So with digital scarcity and proof of authenticity are real game changers in the kind of digital media space. But some of these supposed advantages have seen issues in practice. For example, while the blockchain may be incorruptible, users and the underlying smart contracts will have vulnerabilities at times. Just as one example of this, OpenSea, one of the largest, if not the largest, NFT marketplace, was subject to a breach in February where approximately 250 NFTs with a value of about 1.7 million of current value were stolen through phishing attempts and smart contract vulnerabilities. And that is just one example. There have actually been a number of examples where smart contract vulnerabilities in NFTs and cryptocurrencies and blockchain generally have resulted in thefts of user funds. So this is not a panacea. Just because NFTs offer this proof of ownership doesn't mean that it's a perfect system. Whenever the technology is involved, there will be vulnerabilities that brands and users, consumers, and regulators need to be aware of to mitigate those risks. So how are we seeing brands use these NFTs? Well, we are seeing them use NFTs both as an independent source of revenue and also, and probably more significantly, to foster brand engagement. So we are seeing NFT projects take form of a basic collectible to a more complex gaming environment, social media elements, music distribution, access to private online communities for fans. We're also seeing NFTs being used in sweepstakes and prize promotions, which in one of our other modules, either on the second or third day, we'll get in a lot more detail on those, as well as charity fundraisers. So there is a large gamut of NFT projects that brands are using, each with their own unique kind of flavors. And so it makes this industry very exciting to view and think about, because of the different aspects and sides to which people can get involved. Lots of opportunities. Probably the biggest player in the NFT space right now are the NFT marketplaces. A lot of brands will partner with NFT marketplaces in order to offer their NFTs or establish their NFT projects rather than setting up their own proprietary technological solution. It makes it easier, it's more streamlined, but it also means that you are somewhat beholden to the NFT marketplace's terms, how they do business. And whenever you're a brand and you are doing, for example, due diligence on a partner, you want to make sure that they are in compliance with the law in your jurisdiction or in their jurisdiction where you'll be offering NFTs, etc. So this is definitely kind of a weird time because each of the players in this market, whether it's the marketplaces, brands, or consumers, are trying to figure out where they fit in a kind of a larger regulatorily changing environment. A lot of these marketplaces have grown incredibly fast. And so their systems are struggling to kind of keep up with the increasing demands, whether that is intellectual property infringement monitoring, content monitoring, or AML kind of OFAC, who are your customers? Do you know who your customers are? Issues. So there are a lot of questions that are kind of swirling around that everyone in this space is kind of trying to get a better handle on, and it is evolving very quickly. And I'm going to hand it back to Chris O'Brien to talk about NFTs and games.
Yeah, so this is a fascinating use case, and we're just in the first inning of this. If your practice or your industry touches on games, video games, this is one you're going to want to pay attention to. So there's a rise of NFTs and games, or NFTs being used in games or in tokenized environments. There's an example of one here, but we've seen a lot of them rise, and you'll see a lot in their wake. NFTs can play a lot of different roles within a game structure. We've called out some of them here. And they may be in a tokenized environment where they're interacting with a token or somebody's able to earn tokens. And both the NFT and the token typically can be traded on exchanges, traded for money on exchanges. So think for a minute what that means, what this model means. The typical model is you go buy the video game platform in the video game and you play it. The business model there is the video game company makes the money. This is a model where by playing, the players can make money through tokens, through NFTs that they turn into money, these so-called play to earn models. Well, if you're a gamer and you have a choice between two games you like equally, they're equally fun to play, and on one you pay, and on the other one you earn, that's a game-changing potential model for the video game industry. And they're aware of it, they're afraid of it, they're trying to figure it out. And if you work in that area or have clients in that area, you should be thinking about that as well. We've highlighted something at the bottom, which goes over into the next slide, which is, are these securities? Under the text, I'll stay on this slide for a second. Under the Supreme Court test, which we will talk about in a second, it's not clear that an NFT or tokens in a play to earn game model aren't securities, even though the primary thing may be to play. If it's a model where people are earning money, and some of these have the potential to be real money-making ventures for the gamers, we're going to run into that issue very quickly. So Chris, if you advance the slides, this is just what we're going to talk about. We're doing a deep dive now into legal issues. By the way, I should have mentioned at the top, if you have questions, feel free to put them into the chat. We'll probably answer them at the end, but if we don't, then we will reach out to you and answer them offline. But Chris, if you go to the next slide, I'll dive right into what really has been traditionally the most prominent legal issue in crypto in the United States, which is, are these tokens or NFTs, which is a kind of token Are these digital assets a security? Under the Supreme Court test set forth in 1946 under Howey, it's really four prongs: an investment of money in a common enterprise with an expectation of profit from the efforts of others. It doesn't have to be called a security. There's a concept of what's called an investment contract under this case and under subsequent cases where the issuer didn't call it a security. They didn't call it common stock or preferred stock. The question the Supreme Court was trying to ask is, what's really going on in the underlying transaction? And if what's really going on is a contract or a linked series of relationships where somebody's investing money in the efforts of the entrepreneurs, then that's going to be a security, even if it's not called that. Now, let's apply that to NFTs for a second. I think in its classic form, the NFT probably is not at a high risk of being a security. When I say classic, that's a little bit tongue in cheek because we've had classic NFTs for about 18 months, unless you want to go back to CryptoKitties. But what I mean by that is really a work of art, a finished product, a collectible that somebody's interested in. In general, that's going to have its value derived from the thing. You want to own the thing. You are interested in the artist and what the artist does next, but there's intrinsic value in the thing that you're buying. I don't think that's really in a high danger category of being a security, but this marketplace and this technology is developing very rapidly, and people are doing things like fractionalized ownership of underlying assets and calling them NFTs, or a whole bundle of rights. And Jim and Josh are about to get into the rights picture behind NFTs, and the questions become a lot more nuanced. What I would say in this is, don't blow by this issue. If you're a practitioner, or you're a company that's working in the space, or you're an entrepreneur, the word on the street is NFTs aren't securities. Well, in its classic sense, I might not feel too bad about that statement, but just because you call it an NFT doesn't mean it's not a security. And there are some really bad things that can happen if you issue unregistered securities in the United States, including criminal things in certain instances. When I was a kid, we used to say one nuclear bomb can ruin your whole day. Well, one SEC investigation can ruin your whole day. If the SEC comes in and says you issued unregistered securities, that's a bad development. So don't miss this issue. It's going to be a case by case and a factual thing. I'm going to turn it over now to Jim and Josh to talk about deal issues. How do you get these things done? What are the intellectual property considerations underneath, and what have we seen in doing the many deals that we've done in this space?
Thanks, Chris, and appreciate the opportunity to speak to you all today. Yeah, Josh and I are going to kind of tag team as we talk through the key deal issues centering on a lot of intellectual property points. I think the key thing to identify that comes up in this slide is, of the 5 bullets, 2 of them represent really the intellectual property foundational questions. What are the rights? How are they being expressed, used, protected? The last 3 go to the other side of the coin, which is more traditional contract law, which goes to the terms under which an NFT might be sold. We're going to go a little deeper on the first 2 points in subsequent slides. I do want to highlight, just to kind of think through top line considerations. So understand the IP that you're dealing with, and then understand the contractual terms and enforcement thereof. If we focus on the last 3, the royalty piece is obviously key. People are doing this in some cases for pure branding and recognition in that regard, but often there's a monetary driver to the whole point of owning and selling NFTs. So being clear as to what the royalty structure is, the primary and secondary sales, picking up on what Chris O'Brien said earlier, one of the unique things here is the ability to have a tail as it relates to the ownership of art. So where an artist might have, sold a painting before, subsequent sales were not things that were trackable, and therefore were not areas or royalty opportunities. They are in NFT deals, but you do need to be mindful, how's that secondary market going to work for you, and are you really going to be capturing the dollars down the road? The marketing efforts, just to pick up on, it is typically the case that there is some sort of promotional aspect or other efforts to really drive the market for the NFTs. Again, some of these are brand plays that are using it as part of a broader offering or launch. Some of these are artists or individuals who are looking to sell their wares, so to speak. But in any case, a hotter market and a more exciting market tends to drive higher value. So there's typically marketing elements associated with it. And then lastly, the enforcement of terms point is key, which is, as is true really with the, I guess I'll say the nascent internet, we've made some flashback references, but where the initial terms and conditions or other things for web pages or otherwise were a little bit casual, and they've evolved and certainly have meaning in the do what you say what you do, privacy policy and otherwise. Similarly for NFTs, it's very important that you do spend the time on the terms both by which you're providing your asset, if you're the asset owner, the artist, or IP owner, and also the terms under which they're actually going to, the platform or other vehicle will be offering that NFT to the public. And then one of the big questions we'll touch a little bit, but there's very little history now of enforcement activities. And what's the real ability to enforce the terms that you work hard to achieve? So Josh Kaufman, I don't know if you've got additional elements to add in. You may want to pick up here with the IP foundation.
Jim, can I ask a question or ask you and Josh to weigh in on something?
Sure.
One of the promises of NFTs that we were all hearing at the beginning was secondary royalties forever to the creators. That as the NFT was resold in secondary marketplaces, the original creator would get a royalty, a 10% royalty or some royalty. How is that actually playing out? Is that promise actually occurring with artists and rights holders and creators, or has that proved to be illusory so far?
Again, it's anecdotal, but we're not finding, well, we're finding that a lot of these are not working, especially when people are changing platforms. You buy it on one NFT platform and then you sell it on another. And these, quote, smart contracts that are supposed to be attached are not. One of the things I'm going to talk about in a little bit are, are smart contracts really contracts, and do you need a written contract? But just going back to just the overview point, one of the things that this brings up, and it, for many of you who've been practicing for a little while or a long while, every time there's a new technology, the law does, the copyright law doesn't change to match it. The case law takes years to catch up. So what I coined is you're putting oval pegs in round holes. They don't really fit, but we have to make them fit. So all of a sudden we see all these new deals and we're trying to figure out, we pull out our old form contracts and try to tweak them or to make them work. When the VCR came out, you had to figure out how movies and things fit in. With music, we were doing music for years, and then all of a sudden we have digital downloads and we have streaming. You've been doing publishing work, and then all of a sudden we have ebooks. You're doing newspapers and or wire services, and all of a sudden people are trying to sell news through websites or your phone. So this is a constantly changing environment, and you've got to be on your toes to keep up with how this is working, and being very limber in doing that, because again, round pegs and oval holes, and you have to try to make them fit as best as you can. So, ready to go on to the next one then?
I think it's probably worth touching on the overall clearance in the first place, right? Picking up on your comment, Josh, and the traditional IP rights, they don't change. The foundational elements from an intellectual property aspect to NFTs really do come down primarily to trademark copyright rights of publicity. And if you're selling it, and certainly at the end, if you're a buyer, the question is, are those rights available? There have been cases, the Quentin Tarantino case, where there are arguments, again, have existed in different expressions of intellectual property in the past as to, does Quentin Tarantino own the rights that he's then looking to pass on, sell, license? And the key with any NFT is starting with the, do you own the rights? Do you have the trademark, copyright, rights of publicity necessary to be able to sign up to the license grant that you're looking to do? One of the things, and we've got good past experience in enforcement efforts, which is a limited area with the history of NFTs being, relatively short, as noted earlier. But if you're a brand owner, it is important to think about kind of getting your house in order first, which is you may want to be filing additional trademarks or doing additional things that will give you a better foundation for taking action in the event that somebody tries to do a knockoff or tries to do a variation on what you're offering. So it's just get the IP house in order in the first place as to what do you have, and make it as strong as possible on the outbound, and be in a position to enforce your rights as necessary.
Yeah, okay, but what we need to, I think, we're talking about creating the NFTs and NFTs. First of all, let's be clear, in terms of what an NFT is. An NFT is metadata. It is a numeric number. It's a slight description, and it's a hyperlink to a third party's website. There are no copyrights, trademarks in an NFT. When you own an NFT, be clear that you do not own any IP in and of itself. You don't, in the classic NFT, you don't have any rights to that, the artwork, the music, the written thing that is being linked into the hyperlink that takes you there. It's a third-party right. And if you don't own the underlying material that's being linked to, and we'll talk about it, that's probably a copyright, trademark, or right of publicity violation. But you need to be the rights owner to sell an NFT of that underlying property. And again, NFTs in and of themselves, unless there's a transfer of rights as part of the transaction, as part of the smart contract or a written contract that goes along with the NFT, you're acquiring no rights. Now, you could, in theory, you could acquire physical property along with it. You can, and if the license agreement says that we're granting you the rights and, to do this X, Y, and Z with the underlying copyrightable or trademarkable or right of publicity asset, then fine. But in and of itself, be clear, you're not getting any rights at all to exploit or use the underlying related documents. And when we're talking here, and then I'll turn it back to you, Jim, when we're talking about transferring IP rights, remember that for under copyright law, you cannot transfer a copyright or grant an exclusive license unless there's a writing. So here's an interesting question for you. Is a smart contract in an NFT considered a writing? Can you actually transfer a copyright or an exclusive license simply by having it in the smart contract that's never signed by the copyright owner? I think that's a big open question that you need to do. So as Jim was saying, you really need to look at these transactions individually. Look at the terms and conditions in the platforms. Look at what rights are being granted or not being granted before you go out and exploit. And if you're exploiting your own asset, make sure that those contracts, smart contracts accompanying hard copy contracts, and other terms are very specific. So you know what you're giving up and there's no ambiguity about it, because a lot of the cases we see are because of the ambiguities. People, paste and cut other things that really don't apply, and they don't apply. So,
I think the only thing I'll add on this is, as we're settling in, right? The NFT typically represents a license right, not a full transfer of ownership. And as being pointed out with the eyes here on the last bullet, most NFTs come with a license, which is a display for non-commercial purposes. Unique situation is Bored Ape. Many people have heard of the whole philosophy and design behind the series of Bored Ape is that there is a commercial license. So you're starting to see, and there are, and we've worked on deals where you may have a Bored Ape restaurant, or you may have a Bored Ape bag or other kinds of things, because it's permitted within the terms in acquiring these NFTs. But to Josh's point, make sure you're aware of what the scope of rights are that's coming to you if you're buying it, and if you're selling an NFT, what scope of rights is associated with the NFT that you're trying to sell? Do you have those? Can you transfer? So next slide. Here, and picking up on Josh's comments too, I mean, part of this goes to, not only is it the puzzle because you've got different platforms and there's, I guess I'll say, a noisy environment when it comes to contracting. A lot of the times you have terms that are presented, they're rather limited, and again, going to questions of enforceability. Also, you know, if you're on the plaintiff side, are you in a position to take action? But also on the defendant side, what terms did you really agree to? This is an area that I think, and we were discussing a little bit before this too, as the volatility in the NFT market increases, I think it's likely the case we're going to start seeing more fights over things, because, you know, in a rising market, people tend to have a little less anxiety and friction. In a declining market, what did I actually buy? What's going on here becomes more of a subject of interest. So Josh, I don't know if you've got additional items to add in here.
You know, in this, when you're talking about licenses, and again, you know, I was talking about in writing, well, I think it's fairly established that browser licenses aren't enforceable. You know, something's, you know, has terms and conditions in light gray print at the bottom of the 12th screen on a website, you know, that leads you to something. The courts have not enforced those. Click licenses are, where you actually say, I agree, or there's some affirmative action where you're clicking on them. So if you have a license term that's buried in a terms and conditions, and there is no mechanism to click, I accept or I agree, very unlikely that those are going to be, you know, enforceable. So again, you know, it goes back to, how are you acquiring these rights? We're looking at regular law, what has to be in writing, what can be an implied license, what's an exclusive license, how you use them, how you acquire them. And also, you know, my own bias is, if I'm doing a sophisticated, expensive deal, I'm not talking about clicking and buying, you know, an NFT of a, you know, of a print for $400 or $5,000. But if I'm talking about brand, and I'm talking about, you know, something serious, I want a regular hard copy contract that's been negotiated that goes along with those rights, because in a sense, NFT is just a medium. So if you're going to be licensing your trademark or your copyrights, and you normally have a full-blown contract in regard to those, just because it's an NFT and it's on the blockchain doesn't mean you should throw out all the caution that you've used over the years in protecting your brand. So, you know, these simple browser licenses, or even some of the click licenses, I would look at with caution.
Yeah, guys, to broaden this out a little bit, first, technical point, administrative point. The code for this MCLE, which you'll need to put into your form, is nuts and bolts 2022. Doesn't matter how you spell it, how you space it. So for everybody who's getting MCLE credit. But for you, Jim, and you, Josh, let's talk about the metaverse for a second, and these issues in the metaverse. By the way, everybody says the metaverse, but there are actually a number of different hosted environments that are metaverse environments. It's a persistent digital world that people and brands can go into and do things, right? How do I, as a rights holder, enforce if I go into one of these metaverses and I see somebody infringing on my rights or using my brand. I know you're going to talk about this a little bit. Where do I go? Am I suing the host of the metaverse? Am I suing the other participant? Do I go where the servers are? Is that where I bring my action? Like, just give me a thumbnail sketch of how that works if I'm seeing my IP being infringed.
I'll start on that one because we've at Venable, I've taken down probably about 1,000 NFTs now that are infringing. You know, market data shows there are 200,000 to 300,000 infringing NFTs any day out in the marketplace, according to some survey. If it's a copyright violation, you have the DMCA, and whoever is hosting the infringement, you can send them a DMCA takedown. And our experience actually with the NFT platforms is much better than with the traditional, shopping platforms, where you find infringing and counterfeit goods. They tend to drag their feet. So far, the NFT platforms, 24 hours, everything is down. So we do that. With trademark, obviously, people sometimes don't realize it doesn't apply. The DMCA doesn't apply. But again, we've had very good luck with writing a comparable letter to the NFT platforms to get trademark and right of publicity things taken down. If you're going for monetary, that's a trickier question, because you got to find the defendants and everything is anonymous. And you might need to go through subpoenas and so on, to identify people like you would in an internet case. But so yeah, we do tons of it, enforcements and in the classic, DMCA trademark takedowns.
I'd also add in, and picking up on Josh's point, it goes to my two prongs of IP rights and contract. At least so far, there's a lot more effectiveness of approaching these things as what they are, IP assets, and taking action as Josh described based on the underlying property rights than pure contract claims. This goes back again to the comment as to under what terms were they sold. The decentralized nature that's really the value of Web3 and metaverse is something that as lawyers makes it a little more challenging, where you kind of want to go to a central authority, a courthouse or a government to take action for whatever it is that you're trying to have enforced. And so the property rights are foundational and the important hook so far, with the contractual rights still to be tested, smart contracts and more traditional contract enforcement actions. So key things to keep in mind here as we're talking about the transaction itself is that one of the things we focus on very much when we're the rights holder in these deals, particularly as Josh noted, if you're coming from a brand standpoint with brand integrity to protect, rather than someone who may have a little more ephemeral or light concerns when it comes to their actual property rights. They really just want to make money off of selling an NFT. But in those areas where you're a brand owner, you've got IP that you care about, it's important to make sure you diligence who you're going to do business with in this universe. There's better players and worse players in the overall mix. And part of that goes to how do they actually approach the transfer of the NFT and enforcement. We look for opportunities to make sure that the platform itself is going to stand behind the terms under which an NFT is actually sold. Therefore, someone is on the front line trying to enforce the rights. That's not always easy to do. It seems intuitive in some ways that you would place your asset with somebody who sells it, that they're going to take the action. But as is pointed out here, oftentimes the platforms are really trying to be very light intermediaries. But the reality is, the more these are real assets going for real value, the more this current platform approach is somewhat inadequate to actually both work for the rights holder and also have a viable way to take action against those that may be acting inappropriately as to what they're doing with the asset. For example, you bought an NFT that represented limited non-commercial rights of display, and you turn around and you're starting to sell t-shirts or doing other merch opportunities with it. Again, in the case of Bored Ape, that's permitted. In most other NFTs, not permitted. And how are you actually going to cause someone to stop doing what they're doing? IP rights enforcement, and yes, contractual efforts as well.
Yeah, and this slide here, I think we don't have time for all the details, but this slide's an important slide because the platforms are acting as marketplaces and are claiming we're a marketplace, we don't have liability, so everything is being sold as is. NFTs get burned. If they're linked to a hyperlink and that goes down, the NFT might be worthless. If people aren't honoring the smart contracts, as Chris mentioned earlier, these are all things that the marketplaces are not generally standing behind. They're doing it, we're a marketplace, that's between the buyer and the seller. And of course, the buyer and the seller are totally anonymous. So it makes for interesting enforcement.
Here, I think the items to highlight, this is an example, folks probably have heard of it in the Metaverse, where we've got an artist who created interpretations, riffs related or derived from the underlying bag. Hermes, who has the bags, is not happy with the artist who's gone out to do these variations. And on one hand, it's a artist dispute with an established brand as to what's the scope that someone can actually do or undertake First Amendment rights and interpretive artistic freedoms. On the other hand, it's now being fought about in the metaverse and in the NFT world, and so the ability to actually take action becomes a little bit more restrictive than if it was something that was just being sold out in the marketplace, where there's much more established. Picking up on Josh's comments, round pegs and round holes. Now people are having to figure out how to manage the enforcement. So, but in any action for NFTs, the considerations or steps in enforcement, the marketplaces themselves, are they taking action, or are they washing their hands of the whole event? Social media that can call out whether there's concerns or issues. In this case, the fact that this action has been undertaken has gotten publicity, and the value of these NFTs have dropped considerably, with buyers rightly recognizing maybe I don't actually have what I think I was buying. Actions can be taken associated with trying to recapture some of the currency or funds associated with transfer. And then you've got more traditional legs of the litigation, which again, in recent experience, which is really mostly what we have to go off of, the litigation has primarily centered on a property rights claim as opposed to a contract rights claim. And then the government can get involved. I think, Josh, you were speaking a little bit earlier too, leveraging DMCA and otherwise. This is yet another area where the tools of enforcement are the same as they were. They're just being applied in a new medium.
Yeah. So on just real quickly, 30-second thing on the Metaverse. First of all, it's between two parties. No one bothered to bring in the host. So a partial decision just came down in the case where the court said, as to the images, as artworks, the traditional Rogers Garibaldi standard applies, where you can use trademarks in art. So they said, so when they're showing these merely as artworks, it may be okay. They basically said Rogers' test applies, and then they didn't really apply the test. But they said if they start selling these in the metaverse, in Web3, then they're selling goods, and then you don't go to the Rogers Art First Amendment test. Then you go back to the Polaroid test of likelihood of confusion, traditional trademark test. So this is ongoing, but we did get the first decision, on the motions in this case, and it was a bifurcated decision. But if you're going to be doing this and selling these things on the web, Web3 or metaverse, this case is not good for you. If you're doing them as artworks, it's pretty good for you.
Chris, you're muted.
Yeah, I just saw that. I find this fascinating. This is a little bit of a use case. Trying to be mindful of time too, guys, because there are actually some great questions that are being asked in the chat. I hope we can get to those at the end. But this is a Bored Ape. This is one of the members of the Bored Ape Yacht Club, this handsome, if somewhat forlorn looking guy. We're about to find out why he's so sad. Fred Simeon was bought by Seth Green. If you can advance the slide, Seth Green, the actor. And Seth was, I think now is again, intent on turning this guy, Fred, into the lead actor in a show. I've seen a little clip of this, a trailer of this. It's a combination of live action and him obviously as an illustrated character. But the NFT of Fred was actually stolen from, or ape napped or NFT napped from Seth Green in a phishing scandal. And he lost possession of Fred, his lead actor in his show. And it made its way to somebody named Darkwing84 who purchased the NFT. And ultimately Seth Green bought it back for, I think, $300,000, which is making him a little sad, I'm sure too, in addition to Fred. And I assume the project is back on the rails. But Jim, what's happening here from an IP perspective? Somebody steals something that a producer bought, and now he's got to buy it back. What's happening here?
Well, and this is a good example of where those contract rights and the IP rights kind of started to diverge a little bit, because it is the case that Seth Green got spoofed or taken, scammed when it came to 3 of his NFTs, actually, including this one. And then, so therefore the NFT owner claims certain rights. It gets into questions as to whether there was a bona fide purchaser in the analysis, and going back to some other claims that you can make as it relates to the underlying IP rights that go to the work that you had already purchased. It is yet another area where we're forging new ground, because the whole notion of a stolen NFT and how does it get handled or treated is something that's evolving. OpenSea, which is a Prime platform, is continuing to have challenges in trying to manage fakes. As Josh pointed out, they can be responsive for takedowns, but in this case, as we were discussing earlier, the NFT actually, I think, was originally purchased on OpenSea, but once it became suspect to this phishing exercise, OpenSea had locked it, so it wasn't available for return. So the actual repurchase came back through NFT Trader to complete that transaction. So again, reemphasizing what I said earlier, for lawyers that are used to having a common enforcement and a common structure, again, the decentralized nature of Web3 makes a lot of the underlying contractual rights much more difficult to track, because of the array of contracts, an array of platforms, an array of things that plug into the blockchain overall. So this is again where I reemphasize what I said earlier. The underlying property rights at this point are more primary in the enforcement effort, but I wouldn't look away from the underlying contractual concerns.
And let me just throw out one question. Did he have to buy it back? Can a thief convey title? The person who stole it, did he get any rights to the thing? Or did Seth Green still have the rights because it was stolen? And did he have to buy it back? So again, going back to, look, can a thief take title? Can a thief pass title? To be continued.
And as the franchise perhaps grows to great value, is someone going to be more concerned about, maybe they think they've got rights that they didn't really care about, but now that it's worth more, they're going to press the point.
This is a very unusual way to develop a show, right? based on a character that you bought on a platform not from the original rights holder, in reliance upon a license, which I understand just sits somewhere on a website from Yuga Labs. I mean, would it make more sense to go back and get some rights from Yuga Labs in the first instance under a written contract and then develop the show based on that? Maybe. I don't know the answer to that, but this is clearly an unusual way of developing intellectual property, and it's based on a bunch of intervening events and parties that we don't usually see. Anyway, let's advance on. I don't know if this slide relates to that conversation or if we want to go to the next thing. You tell me.
I think in the interest of time, we probably can move on here to the AML.
Yeah. So switching gears a little bit, we talked about securities risks earlier in the presentation. The flip side in the cryptocurrency NFT world is money transmission risk and anti-money laundering compliance obligations. Similarly to how we look at classic NFTs from a securities perspective, in the sense that a finished product wouldn't really be a security, we kind of have a similar thought process for money transmission risk. A truly classic NFT is non-fungible, and the most classic use of currency or funds or monetary value is that it is fungible. It is the kind of key difference between a cryptocurrency and an NFT. They both rely on blockchain, but the NFT is supposed to be non-fungible. However, like with the securities issues, a lot of people in the industry are getting very creative, and they can attach the word NFT to whatever they want. No one is policing how you use the word NFT. So there are possibilities of implementations that could raise money transmission risks. For example, if it is a highly fractionalized NFT where you have a million subparts of one NFT, is the use of each subpart now fungible? And could that be considered value or monetary value for purposes of money transmission? This is all kind of new ground. And so on these kind of more fringe cases, it is something to think about if you are kind of trying to push the envelope. As one other example, if you have an NFT that issues cryptocurrency as a nature, as a fact of ownership of it, if cryptocurrency is being issued and then dropped into your wallet by the fact of owning that NFT, that could potentially raise money transmission and AML kind of compliance concerns. And then, of course, another flip side is consumer protection. There is a lot of fraud, both intellectual property and on the kind of just the theft, phishing attempts, hackers, scammers in this industry. Whenever there's a new novel kind of technology and it's blowing up, there's going to be opportunity for fraud and bad actors, and NFTs are no different. So it's very important as a brand to kind of be aware of the consumer protection concerns and to mitigate those concerns. One way to do this is to, if you're offering an NFT, link your official NFT website through authorized channels. Make sure you're using your official social media handles, because a lot of phishing attempts will try to mimic your website. They'll try to mimic your social media handles. And if they get access to any of those through like a marketing person's account to Discord or any other kind of social media site, and then they start posting links to a fake website that mimics your website, you're gonna have a problem. And that's happened before. So you'll want to alert your consumers through authorized channels to the occurrence of any scams related to the offering. If applicable, any kind of rarity disclosures. If you have some type of a rarity in the NFTs that you're offering, you want to be able to disclose how rare they are. If it is a loot box type of scenario where consumers don't know exactly what NFT they're going to get. They just know they're going to get like 3 within a kind of a set. You might want to disclose the odds of getting the highly sought after NFT. That's very similar to the loot box mechanic that some video game manufacturers and developers have gotten in trouble for, both on the kind of plaintiff's bar side and also getting looked at from a regulatory perspective by the FTC. So these are all kind of just questions to kind of think about. Of course, we'll talk about prize promotions, sweepstakes, and contests a little bit more in our other presentation, but there is an entire body of law that backs prize promotions and sweepstakes, and all of those same rules are going to still apply. Just because you're using an NFT doesn't make these regulatory regimes inapplicable. They still will apply, and so you still need to know the rules of the road.
Yeah, and folks may want to tune in for the advertising and promotion module that we're doing in a couple of days. This is our last topic, which is good because we have about 4 minutes, 3 or 4 minutes left. Litigation is only going to accelerate, and we're getting some great questions actually in the chat, mostly about enforcement, and we'll try to answer those questions privately. The Top Shot litigation at the top here is a plaintiff's class action suit alleging that the NFTs are securities, which has been the main legal issue in the US in the space. We'll keep a close eye on that. I'll mention tangentially that there was a bill introduced last week by Senators Loomis and Gillibrand, a Republican and a Democrat, to regulate the crypto space. It's actually pretty good. It's very well thought out, but it's probably going to be years. So if you're hoping the cavalry is coming for the space, it may, but it's going to arrive in a couple of years if it does. The next bullet point, the Playboy case, is the first reported NFT case, and it's actually a venable case. We represented Playboy in the takedown of this. Jim and Josh, do you want to speak to the platform enforcement or jurisdictional questions quickly?
I'll speak quickly, and I think it ties partly to the enforcement of one of the questions we received. But the platform enforcement of its commercial terms, any of the commercial terms are going to have standard choice of law, venue, or other type questions. But again, the decentralized nature of where can you actually attach, can you find the counterparty, which ties into the jurisdictional questions and international issues. If you've got a buyer in India, and you're a seller in the US and you say New York law, how are you actually going to take action on the contract? Those types of questions are still open. How's it going to work? I can foresee having more of a modular approach to sales so that it may not be people quite as fully globally as is operating right now as the reality of enforcement comes into question. But again, I repeat what I said earlier, therefore, the underlying property rights are the foundational tool that people have been using to date, like in the Playboy case, to preserve rights. But it doesn't mean you should ignore, and it's important to stay on top of the commercial terms, scope, and the enforcement questions, with the big question being, who's actually going to take action and at whose cost in the event that there is some issue that arises in a transfer or sale of NFTs.
The Tarantino case is kind of famous, so I won't spend a lot of time on it. That's a case where apparently he was selling NFTs that were screenshots of his handwritten script. And the question, which a lot of people in our audience may be facing as rights holders or studios or networks, is in an old contract that didn't contemplate NFTs, where do the rights lie as between the parties to the contract? We always see this language, technologies now or hereafter devised. Well, here we are. We're in the new devised technology. And a lot of people will focus on that. Josh, I think we have about a minute if you want to cover the Nike suit. You're muted, Josh.
sorry, in the Tarantino case, he reserved the rights for print publication, including without limitation, screenplay publication, making of books, comic books, novelization, audio and electronic formats, as well as applicable. Well, is an NFT any of those? And that's, the question we keep getting. The Nike case is a different kind of case. So you have StockX who sells sneakers. Now, their whole raison d'existence is that you send your sneakers to StockX, they verify that they're not counterfeits. There's a huge counterfeit market in sneakers. So they verify that they're not counterfeits. They then give you an NFT, which is kind of like a claim check. And if you ever want those sneakers, you want to buy the sneakers and such, you give them back the NFT, which is an image of your sneaker, and then you get the sneakers. So Nike is saying that it's more than that because they're making NFTs of their goods, and they're taking, they're saying, it's not just a claim check, it's a violation. 43A is a big part of this, misdesignation of association, affiliation, sponsorship. They said they've been getting zillions of calls and comments saying, oh, you must be associated with StockX, classic, trademark confusion. And now they actually just filed last week an amended complaint saying that notwithstanding StockX's claims, they're actually selling some counterfeits, and StockX is saying, wait a minute, you were just in here and you verified what we're doing. So there's another whole non-NFT aspect of it. But basically, it's a whole different kind of NFT. It's a claim check. And, does that violate trademark law? So in a nutshell.
Right. Well, we have run out of the most valuable commodity that exists, our time. Some concluding thoughts here that I'll leave people to read, but thank you for spending the time with us. We will try to answer questions that were in the chat. We hope you enjoyed it. We hope you'll tune in for the tax module and the advertising and promotion module. And we look forward to continuing the conversation. I suspect we could have continued for a long time and had a fruitful conversation, but more to come in the future. And to my panelists and all the folks who support this at Venable who do such a good job, thank you.